Good afternoon and welcome to another episode of Lunch and Learn, your weekly Lunch and Learn session where we discuss all matters pertaining to children as well as child maintenance. And today we will be discussing the parental responsibilities and rights, specifically focusing on married and unmarried fathers. So what we will be discussing today is just to give you a general overview of what parental responsibilities and rights are. What are those in terms of the Act? What is the definition of a parent and what is the definition of a child? And also what is in general meant by parental responsibilities and rights? The duty of care towards a child, the duty to maintain contact with a child, to act as guardian of a child, and also, very importantly, for our purposes, the right or the duty to contribute to maintenance towards a minor child. We will also be discussing, and Erin will take us through the whole presentation, is when can you acquire parental responsibilities and rights? When do you get that right? Is it automatically or do you get that by means of legislation? And how are these parental responsibilities and rights shared between the parents? And how does a married or an unmarried mother acquire, or father then rather acquire parental responsibilities and rights? And what are the rights specifically when it comes to maintenance of the unmarried father with regards to maintenance disputes when they are not married to the mother? And then we will also be discussing some of the major decisions that might affect the child, the upbringing of a child, such as what emergency hospitalization, emergency operations, and so forth. So that is all that we will be discussing during the course of this webinar today. Just as a matter of some logistics, if you have registered, you would have received a link bringing you to our webpage. Our webpage is where you would find some of the pre-reading material that is also available for this specific webinar. Erin compiled a pre-reading material, which you will find under the pre-reading tab. Specifically with regards to the rights, just some background information on the rights and the responsibilities of the parents. Very important. Then on the handout and resource section, you would have access to the Children's Act as well as the Constitution of South Africa. And then all the handout, which is obviously a given on every Wednesday, we give out a handout. You would have access to download that as well as the slides that we will be discussing during this webinar. I have also included a couple of articles which might be a very interesting read, specifically dealing with some court decisions and the implications for social workers. And although it's mentioned that it is applicable on social workers, it's also in a maintenance setting. We could get some valuable information there. I've also included a booklet from the Department of Social Development, just to give you a brief understanding of how they explain the Children's Act. And I've included two very interesting theses, and these are all for recognition of the doctorate in law, dealing with acquisition of parental responsibilities and rights, as well as the grandparental rights and responsibilities in light of the best interest of the child. Those are very interesting reads that you can download at your leisure to read when you have time and availability. But without further ado, I'm going to hand over to Erin. That's going to take us through the presentation, and I'll be joining just for a summary right at the end of the webinar. Right, over to you, Erin.
Welcome back, everyone. Let's get right into today's Lunch and Learn webinar. So the first topic up for discussion is the general principles of parental rights and responsibilities. So the Children's Act, specifically in section 18.2, sets out the parental responsibilities and rights of parents. So it reads that the parental responsibilities and rights that a person may have in respect of a child include the responsibility and the right, A, to care for the child, B, to have contact with the child, C, to act as a guardian of the child, and D, to contribute to the maintenance of the child. So those are the 4 core parental responsibilities and rights that a parent has in respect of their child. Okay, so we know that the Constitution makes provision for children's rights in Section 28.1. So Section 28.1 specifically sets out the rights that children are entitled to, in addition to the rights that they're entitled to in the rest of the Constitution. And Section 28.2 states that the best interests of the child are of paramount importance in all matters concerning them. So the Children's Act aims to strengthen those rights contained in the Constitution. So it strengthens the rights and responsibilities that parents have towards their children in terms of the Constitution. So the courts in the case of GM versus KI made it clear that parental rights and responsibilities are inseparable and they should be seen as a collective. So you cannot have one without the other. So they are seen as a collective. You have rights and responsibilities in respect of your child. So then it becomes important to know who is a parent in terms of the Children's Act, because only biological or adoptive parents have these parental rights and responsibilities in respect of their children. So who is a parent in terms of the Children's Act? Well, a parent in relation to a child includes the adoptive parent of a child, but excludes the following persons. So it excludes, the biological father of a child conceived through rape of or incest with the child's mother, any person who is biologically related to a child by reason only of being a gamete donor for purposes of artificial insemination or fertilization, or a parent whose parental responsibilities and rights have been terminated. So parental responsibilities and rights can be terminated by a high court, but only a high court can make such an order. So those are the categories of people who are expressly, in terms of the Children's Act, excluded from the definition of a parent. So who is a child in terms of the Children's Act? Well, Section 17 of the Children's Act states that a child, whether male or female, becomes a major upon reaching the age of 18 years. So this means that any person under the age of 18 years qualifies as a child. And for purposes of the Children's Act, a parent has parental rights and responsibilities in respect of their child, provided the child is below the age of majority. So the court in D versus D basically reaffirmed the parental rights and responsibilities that parents have and stated that these rights and responsibilities include the right to care for the child, the right to have contact with the child, the right to act as a guardian of the child, and the right to contribute towards the maintenance of the child. So just to briefly go over each one of these core parental rights and responsibilities, we have the duty to care for the child. So care is defined extensively in the Children's Act. You know, for example, the child should have a safe home, have safe living conditions, should not be subjected to abuse, degradation, maltreatment, etc. So care is extensively defined in the Children's Act. You can go and look in that definition in Section 1. Then we have the duty to maintain contact with the child. So the child has a right to have contact with both parents. The child has a right to maintain a close and healthy relationship with both of their parents. And then also vice versa, the parents have a right to have contact with their child. And contact cannot be unreasonably withheld from the other parent. So this will be a criminal offense because the parent has a right to have contact with their child. Duty to act as a guardian of the child. So this is an interesting one. Section 18.3 of the Children's Act sets out the duties that a guardian has in respect of their child. So to administer and safeguard the child's property and property interest, to assist or represent the child in administrative, contractual, and other legal matters, or to give or refuse to give consent required by law. So let's look at that. Section 18.3c, give or refuse to give any consent as required by law, including the following: consent to the child's marriage, consent to the child's adoption, consent to the child's departure or removal from the Republic, consent to the child's application for a passport, and consent to the alienation or encumbrance of any immovable property of the child. So these are the major decisions affecting the child, and therefore the guardian must give or refuse consent in terms of those, I think it's 5, yes, the 5 duties of the guardian. So that's very important to remember. Then lastly, the duty to contribute maintenance towards the child. So this is the financial obligation known as the duty of support in terms of the Maintenance Act. So this is a common law duty of support. Both biological parents have this duty to financially support their child. So this is determined based on the reasonable needs of the child, as well as the income and expenses of both parents. Acquisition of parental responsibilities and rights. So how are these parental responsibilities and rights acquired by parents? And then the logical first question would be, are parental rights and responsibilities shared between the 2 parents? The answer is yes, parents share parental rights and responsibilities. It is possible for a parent to have either full or specific parental rights and responsibilities. For example, the mom can have the right to care for, have contact with the child, but not be a guardian. Or the father has the right and responsibility to contribute maintenance, but does not have the right or responsibility to care for or have contact with the child. So it's possible to have either full or specific parental rights and responsibilities. But under normal circumstances, both parents usually share in these rights and responsibilities. It is also possible for other interested persons, such as grandparents or other family members, who are interested in the care, the well-being, and the development of the child, to acquire parental rights and responsibilities. So they will acquire these parental rights and responsibilities in terms of the Section 22 agreement, known as the Parental Rights and Responsibilities Agreement. It is very similar to a parenting plan, which is entered into between the biological parents of the child. It will set out what specific parental rights and responsibilities that parent, for example, that grandparent will acquire. And it is then also signed by the grandparent and is made an order of court and becomes legally enforceable. So, for example, mom and grandma will share in parental rights and responsibilities, and they have entered into the Section 22 agreement, which is a voluntary agreement. So we will now just look at how certain persons acquire parental rights and responsibilities. So how does a married or unmarried mother acquire parental rights and responsibilities? So Section 19 of the Children's Act becomes applicable here, and it states that the biological mother of a child, whether married or unmarried, has full parental rights and responsibilities in respect of the child. What does this mean? Well, it means that the mother of the child, irrespective of her marital status, will automatically acquire full parental rights and responsibilities. So the mother of the child at the time of birth will have the duty to care for, to have contact for, to act as guardian, and to contribute towards the maintenance of the child. She acquires these rights and responsibilities automatically, irrespective of her marital status. This is important because when it comes to a father, his marital status does play a role in how he can acquire parental rights and responsibilities. So, how does a married father acquire parental rights and responsibilities? So, marital status, married. Section 20 of the Children's Act becomes applicable. It states that the biological father of a child has full parental rights and responsibilities of the child. A, if he is married to the child's mother, or B, if he was married to the child's mother, either at the time of conception, at the time of the child's birth, or at any time between the birth and conception. So if he is married, he will have full parental rights and responsibilities, or if he was married, either at the time of conception, birth, or any time between conception and birth, then that father will acquire full parental rights and responsibilities. How does an unmarried father acquire parental responsibilities and rights? So, marital status, unmarried. Section 21 of the Children's Act becomes important here. It reads, the biological father of a child who does not have parental responsibilities and rights in respect of the child in terms of Section 20 acquires full parental responsibilities and rights in respect of the child. A, if at the time of the child's birth, he is living with the mother in a permanent life partnership. B, if he, regardless of whether he has lived or is living with the mother. I, consents to be identified or successfully applies in terms of Section 26 to be identified as the child's father or pays damages in terms of customary law. Then double I, contributes or has attempted in good faith to contribute to the child's upbringing for a reasonable period. And then the last one, contributes or has attempted in good faith to contribute towards expenses in connection with the maintenance of the child. So the unmarried father does not automatically acquire full parental responsibilities and rights. So one would say there's a bit of a discrimination between married and unmarried fathers, because by virtue of marital status, the married father automatically acquires full parental responsibilities and rights. Whereas the unmarried father, just because he is not married to the mother, there are certain requirements that he has to meet before he is able to acquire full parental responsibilities and rights. Therefore, the law requires him to prove his commitment towards his child before he is able to acquire these full parental rights and responsibilities, which on the surface level seems unfair. Discrimination based on marital status. And so I know that the proposal to the amendments to the Children's Act have now attempted to take out in good faith, the words in good faith. And so we will just need to see what happens. But on the surface level, it does seem unfair that a married father and an unmarried father are treated differently in terms of the Children's Act. So yes, as I've said, unmarried fathers do not automatically acquire parental responsibilities and rights. However, Section 21(2) of the Children's Act becomes very important. So if the unmarried father does not prove the requirements, does not meet the requirements in terms of Section 21(1) of the Children's Act, that father will not acquire full parental responsibilities and rights. So they will not have the duty to care for, the duty to have contact with, or to act as a guardian. However, Section 21(2) makes clear that father will remain liable to contribute towards maintenance payments in respect of the child, even if he does not acquire any of the other parental rights and responsibilities. So that maintenance obligation does not fall away. The father will remain responsible for maintenance payments, even if he does not acquire any of the other 4 parental rights and responsibilities. So, maintenance disputes of unmarried fathers. So we know that they remain liable to contribute towards maintenance payments. So how are maintenance disputes dealt with? Well, throughout this webinar series, we've discussed maintenance in extensive detail. And if there's anything you are unsure of, you can always just go back and rewatch those webinars and just go see whatever is bothering you, whatever you're unsure about, you can just go have a look at those webinars. So we know that maintenance disputes are dealt with in maintenance court. So you will approach the maintenance court nearest to where the child lives, and this will be the court that has jurisdiction to hear your matter. So we have a Section 6 and we have a Section 10 inquiry. Section 6 refers to the informal negotiations between the applicant and the respondent, and then if they cannot reach agreement in terms of the Section 6, it will be referred to a Section 10 formal inquiry, which is held in court. So the Section 6 will be held in the maintenance officer's office. It takes the form of a mediation. The maintenance officer will explain the process to both the applicant and the respondent, and then they will negotiate as to a reasonable amount of maintenance. As we know that both biological parents have this duty to contribute towards maintenance. It's the common law duty of support that falls onto both parents. Maintenance is calculated based on the income and expenses of both parents and the reasonable needs of the child. So this is dealt with in maintenance court. So we've said now, maintenance disputes are dealt with in terms of the Section 6 maintenance inquiry. So the applicant can either by way of the J101 apply for maintenance as a first-time maintenance application, or the respondent or the applicant can apply for a variation of an existing maintenance order. And this is in terms of this J107 application form, for either applying for an increase or decrease of the maintenance amount in the existing maintenance order. And then it will first go through to the Section 6, held in the maintenance officer's office, mediation style, and then they can reach an agreement and they can either sign a consent form, which is the J214, or if there's a disagreement, it will be referred to a formal court hearing known as the Section 10. So the maintenance officer, we know, is an independent third party who speaks to both the applicant and the respondent to ascertain whether they can afford maintenance. It is important for both parties to come to the informal negotiations with complete honesty, give clear and concise information to the maintenance officer in order for that maintenance officer to ascertain the reasonable amount of maintenance. Be honest, actively participate in the informal negotiations, and raise your concerns, validate the concerns of the other party. Approach this with absolute honesty and kindness. Remember always that you have approached the maintenance court acting in the interest of your child. Put your own agendas aside and focus on your child. You are there for them. You have to act in the best interest of your child. And the maintenance officer is there to assist you in applying for maintenance, in applying for a variation, and ascertaining what a reasonable amount of maintenance would be. So a Section 6 inquiry is an informal inquiry by a maintenance officer into the relevant facts complained of. So these complaints include that the person liable to pay maintenance fails to maintain as such, that good cause exists for the substitution or discharge of a maintenance order, or that good cause exists for the substitution or discharge of an oral or written agreement where there is no existing maintenance order in place. So it is an informal process done in front of the maintenance officer. It's not done in court before a magistrate, and it is the first step in the investigation of a maintenance complaint. Each party will get a chance to explain why they require maintenance and or whether they can afford the maintenance amount being requested. So the maintenance officer attempts to settle the matter with the evidence which is presented to them. That is why you need to give concise and honest information to the maintenance officer. If the parties can agree to an amount at the informal inquiry, then a consent form will be made in order of court, and that maintenance agreement will become legally enforceable. So in a previous webinar, we discussed consent orders in detail. So if you're unsure about that, you can always go back and watch that webinar. But just to give a brief overview, is the J214 will be completed in the office of the maintenance officer. both the applicant and the respondent comes to agreement regarding the amount of maintenance, and that consent order is then signed by both parties, and it is signed by the maintenance officer. And then that consent order is made an order of court and becomes legally enforceable. It is even possible for a respondent who is residing in a different province, for example, living in Pretoria, but the application is made in Cape Town. They can, by way of an email or by way of an affidavit, confirm their consent in writing. So it is possible to reach agreement already in the Section 6 inquiry. In the previous webinar dealing with the consent orders, I do give some tips on how you can reach consent already at the Section 6 to avoid having to go to a Section 10 formal court hearing. So just a brief reference to the major decisions made by one parent and then visitation rights. So what are the major decisions affecting the child? Well, we've actually discussed this already. So it's the decisions made in terms of Section 18(3)(c) to give or refuse consent to the child's marriage, to the child's adoption, application for transport, removal or departure from the Republic, or to sell any immovable property of the child. So these are major decisions affecting both the other parent's parental rights and responsibilities, as well as the child themselves. So Section 32 of the Children's Act states that the parents can make decisions independently of one another. So the holders of parental rights and responsibilities are able to independently make a decision without consulting with the other parent, with the other holder of parental rights and responsibilities. However, Section 31AB says that if it is a decision which affects the other holder's parental rights and responsibility or affects the child themselves, due consideration must be given to the wishes and the views of the other holder of parental rights and responsibilities, as well as due consideration must be given to the views and wishes of the child, depending on their age, maturity, and stage of development. So, any decisions which affect the other holder's rights and responsibilities, due consideration must be given to their views and wishes as well. But besides that, we know that they can make decisions independently of one another, provided it's not a major decision which affects that other holder's rights and responsibilities, and it does not affect the child. What are visitation rights? So, when you approach the children's court, you can approach the children's court with a Form 2 application accompanied by founding affidavits to acquire parental rights and responsibilities. So if you have the right to have contact with your child, this is the visitation rights. Normally there would be a primary parent and there would be a non-primary parent. So the primary parent is the parent with whom the child will primarily live on a more permanent basis, and the non-primary parent is the one which the child will frequently visit, but does not live with that parent on a permanent basis. That parent still has a right to have contact with their child. So it becomes important to have visitation rights. So you can enter into a parenting plan. The parenting plan can set out how parental rights and responsibilities will be exercised. This is a legal document that is signed by both parties. It is signed and then made an order of court. The family advocate must endorse it, ensure that it is in the best interest of the child. And then that agreement is legally binding between the parties. So this agreement can set out how visitation will work. So visitation rights can also be limitations or restrictions on a parent's right to have contact with the child. However, courts are hesitant to withhold contact rights because not only does the parent have a right to have contact with the child, but that child has a right to have a close and healthy relationship with both parents. So it is ideal that parents will normally share in contact rights. However, as I said before, care is quite extensively defined in the Children's Act, and the child that is subjected to abuse, degradation, or maltreatment, such a parent that has subjected the child to abuse may have limitations on their visitation rights, on their rights to contact. And this is where we have things such as supervised visitation or phased-in visitation. So supervised visitation means that the other parent or some other family member or social worker must be present when the parent and the child are having their visitation hours. No sleepovers can take place in such a case. And then phased-in contact is also parents who suffer from substance abuse, alcohol abuse, drug abuse problems. The court will rather have the child have phased-in contact to basically get to know that parent and to see if that parent is fit to care for the child and to spend time alone with the child. So that is just an overview of visitation rights. As I've said, supervised visitation, phased-in visitation, or unsupervised visitation. So that brings us to the end of the webinar. This was just a brief webinar because parental rights and responsibilities, these are defined in the Children's Act. And there's only the 4 core ones: the duty to care for, to have contact with, to act as guardian, and to contribute towards the maintenance. The Lunch and Learn webinar series has focused extensively on maintenance. And so this was just a brief overview of the other 3 parental rights and responsibilities as well. Just that you, as a parent, have to take care of your child, ensure that they have a safe home and living conditions, that they have food and shelter. To have contact with your child, spending time with your child is crucial because your child has a right to have a close and healthy relationship with you. And then to act as guardian. So it was only a brief overview, and that just brings us to the end of the webinar. Thank you so much for joining us today, and I look forward to the next one.
Thank you for that, Erin, and I'm sure that the viewers online on our social media platforms have found this quite interesting. If you do have any questions, any queries pertaining to the webinar, if you would like to have some insight or further insight, or just something that is unclear that you need to discuss, please drop us a line on info@landlearn.org.za. Again, my name is Eugene Opperman. I'm a family law practitioner. I've been practicing for 23 years, specializing mostly in family law matters, dealing with maintenance matters, domestic violence, as well as matters pertaining to children's rights. It has once again been a fantastic experience hosting this webinar, and we will see you next week, same time, same place, for another episode of Lunch and Learn. Have a good afternoon further.